The long-running dispute between girl group New Jeans and their agency Ador reached a major turning point on October 30th, 2025, Korean Standard Time. The 41st Civil Division of the Seoul Central District Court, presided over Judge Jong Ho Il, ruled that the exclusive contracts signed between Ador and the five New Jeans members in 2022 remain legally valid. And according to Dispatch, a South Korean publication, courts typically summarize rulings briefly. But this case was an exception. The judge spent roughly 40 minutes reading through each key point of the verdict, rejecting every argument from Nugent's side and stating that Ador didn't violate any significant obligation under the exclusive contract, nor can it be acknowledged that the relationship of trust was broken. Let's go through the background of the case and the decision. First, the background, the termination, and the lawsuit. The decision comes nearly a year after New Jeans held a press conference in November 2024, announcing the termination of their contracts with Ador and citing a breakdown of trust. The group declared independent activities under the name NJZ. Ador responded on December 3rd, 2024, filing a lawsuit to confirm the contract remained valid, arguing that a unilateral claim of broken trust cannot be grounds for termination. In January 2025, Ador filed an injunction to prevent the members from signing new advertising or promotional contracts. The court granted that injunction on March, effectively freezing Nugent's independent activities. The court also accepted Ador's indirect compulsory motion, ordering each member to pay 1 billion won, or approximately 740,000 US dollars, if they ever engage in any entertainment activity without the agency's prior approval. Before this decision, two mediation attempts failed before the case returned to court for full ruling. And here is the final decision. The court said the contract is valid and Nugents has to pay the costs of litigation. The court rejected all of Nugent's major claims, including allegations that Ador's dismissal of Min Hee-jin constituted a breach of duty or that Hybe's audit of her was retaliatory. The court said, and I quote, Min Hee-jin's role is not a core element of the exclusive contract. The court determined that Nugent's trust in former CEO Min Hee-jin cannot be regarded as a decisive factor in their exclusive contract, since the agreement did not guarantee Min's continued role as Ador's representative. It also noted that even after Min's dismissal as CEO, she remained in the position to perform producing duties as an internal director. Further, Ador had offered Min a new contract redelegating her producing authority, but she declined the proposal. The court said, and I quote, Ador continued to pursue Min Hee-jin's reappointment as an inside director. However, she resigned of her own accord. Ador did not unilaterally break the relationship of trust. The court added that the absence of Min didn't really cause a gap in Nugent's album planning and entertainment activities. Nugent further argued that Ador failed to properly fulfill its management duties after Min's dismissal. The court rejected that claim as well. The court stated that the company's delay in recruiting a new producer was due to its initial efforts to seek Min Hee-jin's cooperation. The ruling emphasized that even during this transitional period, Ador continued to operate normally. Management work such as album production, performance planning, world tour preparations, and advertising coordination was consistently carried out. The court also addressed Hybe's audit and retaliation claim. The court sided with Hybe and Ador regarding the audit of Min Hee-jin, rejecting her repeated assertion that it was conducted in retaliation for her raising internal concerns. As part of the ruling, the court cited Kakao Talk conversation between Min Hee-jin and former Ador Vice President Hee Sang-woo as direct evidence because civil litigation in South Korea follows the principle of free evaluation of evidence. The messages were deemed admissible and valid in court. The submitted exchanges presented by Hybe on July 24, 2025, the case's third hearing, revealed that Min Hee-jin had discussed plans for independence months before the audit. In one conversation from February 2024, when Lee remarked, "We're going to make it hard for them," meaning Hybe, "and gain our freedom," Min responded, "That would be great." In subsequent exchange the following month, Lee wrote, "We're changing the plan and moving the timing forward. We won't talk about the media here. We'll file a lawsuit based on public opinion. We'll explode when we get a response." The court considered this premeditation. And the court also referenced a Kakao Talk draft message prepared by Min on April 20, 2024, outlining her plan to file a report to the Fair Trade Commissions. But this time, she wants the mothers of the members of New Jeans to file. According to the court, this action showed that Min had been actively seeking to influence investors and mobilize the members' parents to shape public opinion and become independent, not for the purpose of protecting New Jeans. The court stated that the audit was a legitimate response to this plan. The dispatch trainee videos. The court also examined additional incidents that New Jeans cited as evidence of a breakdown of trust between Ador and Hybe. One of which is the release of a Source Music trainee videos by Dispatch showing New Jeans members rehearsing to the song Attention when they were still training under Source Music. The court said Hybe and Ador actually responded promptly. They emailed and contacted Source Music, and they did the same to Dispatch. It proves that the plaintiff took appropriate corrective action. On I'll It and allegations of copying. New Jeans and Min Hee-jin argue that Hybe's in-house label B-Lift Lab debuted I'll It with a concept allegedly copied from New Jeans. But the court said that yes, there are similarities in the photos, but it does not mean I'll It copied New Jeans. The Girls Next Door or youthful concept is not an intellectual property protected by law. The court further noted that Ador, while under Min Hee-jin's leadership, had already sent an official document to B-Lift Lab expressing concern. That's evidence that the agency had taken appropriate steps at that time. It also addressed the allegation of Hani that a member or manager of I'll It instructed I'll It to ignore her. And they said that based on the evidence submitted, it showed that I'll It actually bowed to her. And since there is no audio, there is no way the alleged statement may be verified. The judge also added that Hani's description of the incident did not accurately reflect what occurred. CCTV footage confirms that the members of I'll It bowed to Hani. The court ruled that the allegation lacked factual basis. On media controversies, the judge also rejected New Jeans' claim that a Hybe PR employee disparaged the group's performance when it requested publications to correct its report that New Jeans sold 1 million copies of their Japanese debut album. Hybe clarified that it merely requested a correction to prevent misinformation that could confuse investors. The judge said that leaving the false report uncorrected could have misled the market. Hybe's actions were standard corporate procedures, not an attack on the group. The court also sided with Ador in its dispute with the Dolphin Kidnapping Group, the external production team behind the ETA Director Scott music video. Ador had requested that the video be taken down after it was posted online without Hybe's prior approval, which was required under the terms of service contract. The judge said, and I quote, Ador's actions against the company were an exercise of contractual rights, not a breach of any significant obligation under the exclusive contract. In summary, the court found that Hybe and Ador's actions in these instances, from media management to production disputes, were consistent with standard corporate governance and did not amount to violations of the exclusive contract. Investment and industry context. In its defense, Ador emphasized its 21 billion won, approximately 15.5 million USD investment into New Jeans, including 7 billion won or 5.2 million USD for their debut album and 1.5 million USD or 2 billion won for their debut music video, with Hybe's active support. The court acknowledged this point, adding that such heavy upfront investment under uncertain success is standard industry practice. It stated, and I quote, in cases like New Jeans, management contracts are often signed before debut with large investments that can only be recouped through success. The fact that unreasonable demands were not accepted does not mean they are being forced to exclusive activities against one's free will or as a violation of personal rights. The judge also clarified that a remark by a member of Hybe's management team stating abandoning New Jeans was taken out of context and merely a part of a strategy discussion about Les Serafim's promotional plan. Another complaint that New Jeans filed is about the Apple campaign. They said that Hybe executives ignored the members or interfered with this brand deal. But the court clarified that according to evidence, Apple approached Hybe even before the debut of New Jeans, meaning it was actually Hybe who gave the contract or the deal to New Jeans. The court stated, and I quote, this is a case where, after building popularity and fandom through an exclusive contract, artists are now claiming decision making authority over personal matters, content production, and others. And when these unreasonable requests were not accepted, the artists are now claiming infringement of personal rights. So what now? Well, New Jeans already filed an appeal through their law firm Sejong. The law firm stated that the members respect the court's decision, but maintain that it is impossible to return to Ador and continue normal entertainment activities in the current situation where the relationship of trust has been completely broken. The five girls are planning to immediately appeal this ruling and hope that the Court of Appeals will review the facts and legal principles once again to deliver a fair judgment. But with the first instance ruling delivered, the case now moves to the Court of Appeals, where New Jeans will definitely challenge the court's interpretation of contract validity and the scope of trust between artist and agency. But for now, the decision cements Ador's legal control over the group and signals judicial recognition of Hybe handling of internal disputes. The ruling reinforces the binding nature of pre-debut exclusive contracts in K-pop. The court, this judge actually validated a lot of the things that were not on the table before. For example, the Kakao Talk messages, he validated that. He said that because of all of the things that we've read, the messages, the exchanges, the files that were found on your computer, it only proves that you actually tried to, and which was already claimed by the initial judge, by the way, in the injunction. He said that, yeah, you tried to go independent. You tried to get New Jeans out of Hybe and Ador. And that justifies what Hybe did, which was to audit you. That, all that. And then he also stated and addressed New Jeans saying that, after all the efforts to make you popular and successful, after all the investments, you think that just because you are successful, you also have the right to make demands when it comes to personnel, processes, production style. He was basically saying that just because you are successful, you think that you are entitled to all of those. And all of those things, but specifically the judge validating the Kakao Talk messages, files that were found. that is going to play a part in her defamation cases, the cases filed against her for defamation. So it's very interesting, and let's see what's going to happen. The other thing is that the Ador actually already released a statement because Sejong law firm, the law firm of New Jeans, already stated that they are going to file a an appeal. And they said that over the course of nearly a year, the court has repeatedly ruled in various related lawsuits that we hold the status of management company under the exclusive contract, and that the artist New Jeans should carry out their entertainment activities with us. After a long period during which many claims and factual matters were examined, we earnestly hope that today's decision, once again reaching the same conclusion, will serve as an opportunity for the artist to calmly reflect on this matter. So I thought it was interesting that they're not saying come back, start working. They're just saying just think about this. Okay, let's see what's going to happen. This is a long battle. They're going to appeal. That can take another year. If it doesn't go their way, they're going to appeal again, and that's going to take another year again. So let's see. What's important is that the other groups in Hive, they are thriving. Le Seraphim, Isle It, Cortis is actually doing very well, and of course, BTS is about to come back. All right, thank you for being here. Please consider donating to the channel. You should see the QR code on your screen right now. We launched our online magazine, asianentertainmentandculture.com. Please visit the site. It's on a soft launch, but I'm hoping to do a formal launch next month. And also, please follow me on X, Instagram, but more importantly on Patreon. That's where the community is. I also do exclusive live streams for members of Patreon and YouTube. So please consider supporting me there as well. Those videos don't become public at all. And I also do exclusive videos for them outside of the live stream. That's it. Thank you so much. Please like the video, subscribe, and hit that notification button, and share the video if you can. But the most important thing, please share because that's going to push the algorithm to recommend this more. Thank you. Till next time.